I'm Dustin Saldarriaga, an immigration lawyer with Scott Legal PC in New York City, and today I'll be answering a common question we get from our E-2 visa clients. While you're on an E-2 visa, what work can you do outside of the E-2 company? It's a great question and one that's worth thinking about since it really can affect the experience of someone on an E-2 visa. But before we dive in, please take a moment to subscribe. By doing so, you'll stay updated on our firm's most current and trustworthy information about U.S. immigration, including options to visit, work, or live in the United States. So, you're in the U.S. on an E-2 visa and you have an opportunity to earn income outside the E-2 business. Maybe it's an opportunity to work at a friend's business, or maybe it's a part-time job to bring in a bit more income as the E-2 business gets off the ground. What's the rule when it comes to these opportunities? Can you take them? Or are they not worth the risk of violating your visa status? The general rule is that while you are in the U.S. on an E-2 visa, you can only work for the E-2 business. In other words, your work authorization is only for the E-2 business and you're not allowed to get work authorization to work for a company outside the E-2 business. Working without authorization is taken seriously by the government and is considered a violation of status. That could impact your future visa applications and could even result in you being barred from re-entering the U.S. So take the prohibition on unauthorized work seriously. Now, something the E-2 visa holder might consider is performing services to outside companies through the E-2 business. Those services would need to be related to what the E-2 business does. The E-2 visa holder would perform the service and the E-2 business would receive payment for the service as a contractor. Here's how this might look in practice. Let's say that you're on an E-2 investor visa to develop and direct a law firm that you own in the US. A law school has contacted you and asked you to teach a course that's related to the work your law firm does. You really want to take advantage of the opportunity, but you also don't want to violate the terms of your visa. By entering into a service agreement between the E-2 company, the law firm, and the university could pay the E-2 company directly for the services that the E-2 investor performs. These payments would be reported on the IRS Form 1099. The E-2 visa holder would teach the course, but the E-2 business would receive the payments from the university. For this to work, the services being provided to the outside company or entity should be similar to those typically provided by the E-2 company. If the E-2 company were a restaurant, for example, it would be difficult to justify its owner teaching a course at a law school, even if the owner's a lawyer. Also, it's usually a good idea to have a service agreement in place between the E-2 company and the company receiving the service that defines the services that'll be offered and the fees that'll be paid. Now, there are a couple other things to keep in mind. In general, there's no prohibition to an E-2 visa holder owning a business as a passive investment. The problem arises when the E-2 visa holder is actively working for compensation, as they would be doing in the law school example from before. If instead the E-2 visa holder wanted to purchase or start a business that they would have no active role in, this is usually permissible. The E-2 visa holder would need to make sure that their involvement is truly passive. For example, they should receive distributions from the company rather than a salary. They should not conduct day-to-day activities at the business, but should instead hire workers to do so. And they should not be actively involved in marketing the company. These are just a few examples and isn't a comprehensive list of the things the E-2 visa holder would need to keep in mind if getting involved in a passive business. If the E-2 visa holder would like to become more actively involved in the business, they could request an E-2 visa for the new company, though the new company would then need to satisfy the E-2 requirements, including the substantial investment requirement and the requirement that the business employ U.S. workers. Finally, remember that the spouse of an E-2 visa holder usually receives unrestricted work authorization upon entering the U.S. on the E-2 spouse visa. No separate employment authorization document is required since this work authorization is granted automatically as part of their status. We hope this video was helpful. If it was, please go ahead and click the like and subscribe buttons to stay updated on future videos about visa options and travel to the U.S. Thank you for watching.